Hi, Senada. Thank you for being here with me and collaborating with the Romnja Feminist Library. The library is a platform for knowledge production that centers on the past, present, and future of the Roma feminism. As part of the library, we have also created a visual archive that focuses on producing feminist and anti-racist content. Through this series of interviews, we aim to dedicate space for Roma women and girls to share their own narratives and experiences. Today, we will be discussing with you your personal journey, your work as a legal director, and your efforts in strategy litigation. Can you start maybe by telling us a little bit about yourself?
Thank you for the invitation. My name is Senada Sali. I work for the European Roma Rights Centre already for 10 years, starting from 2014. And I originally come from Macedonia, or almost 33 years old now. And I started my legal journey very early because I was always motivated to fight for equality and for justice. And this motivation came to me as a result of my childhood. And I am a child raised by a single parent. My parents divorced because my mom was a victim of domestic violence. And this journey that my mom experienced through institutions in North Macedonia as a victim of domestic violence and the lack of protection that we as her children and she had with us was something basically that it stuck in my mind. It's my earliest experience of my childhood because I was only 5 years old when this happened in my family. And after that, throughout the entire life, I was basically just trying to do much more than everybody else in my surrounding. I was trying to somehow impress my mother to make sure that she is proud of the children that she raised alone. And this motivated me basically to fail in my studies, to enroll in the law university in Skopje first. I finished my BA degree, and then I enrolled in a master program at Central European University in Budapest. Before that, I was also a part of the Roma Access program for 9 months, where I was studying with around 20 other Roma from all over Europe. And that was actually the first opportunity where I felt that I belong somewhere. I genuinely belong somewhere among my people. And after that program, yes, I was enrolled in a master for international relations and European studies. I decided to choose this field because I realized that there are not many Roma women that have expertise in diplomacy and international relations. And so I completed my MA studies in Budapest at CEU, and during the summer break, I first time heard about the European Roma Rights Centre because that time organization was based in Budapest, in Hungary. And there was an opportunity for students to apply for internships in the organization. So I was one of those students from Roma Access program that applied. And then I stayed for 3 months only in the organization during the summer. And then after my internship at ERRC, I also got the opportunity to be a legal trainee in the organization. This was also a program that existed in the organization, I think some 8 years ago. Yes, every year they were giving 1 or 2 maximum traineeships to Romani legal students of law who have graduated law. So I was accepted for the legal traineeship, and after 2 years of legal traineeship, I was promoted to a lawyer. And that was the moment in my career that actually was the most challenging and also the most successful. During that moment, at that point, I was the first Roma woman that got the opportunity to work at the position of lawyer. And breaking that glass ceiling, being the first Roma woman who got that chance, meant a lot for me, but also for other Roma women. Because after me, my colleague Vivian Brashoi was the next Romani woman who also went through this journey. She became a legal trainee, and after 2 years, she also became a lawyer at the organization. While I was working at the position of lawyer, I got familiar with strategic litigation, because something that it's important to mention is that our legal universities, especially in Western Balkans, don't really provide a lot of information about strategic litigation. They're focused on being a lawyer in traditional legal cases, meaning you represent an individual client, and the highest outcome that you can achieve is that positive court judgment. And that's it. There, your work finishes. Strategic litigation is something more than that. At the ERRC, for the first time, I learned what is strategic litigation. And it's because the organization exclusively focuses on strategic litigation as one of the main tools or the main tool for achieving changes when it comes to the rights of the Roma community in Europe. And then I was working for a couple of years as a lawyer. I litigated and was directly included in investigation of cases, so in some research and advocacy work, including a large-scale regional campaign of Roma statelessness. And in 2016, there was a big shift in ERRC leadership, where for the first time, ERRC got a Roma gay man president of the organization and a Roma woman chair of our board. So at that time, I was also promoted to legal manager. This was the first time, I think, that a Romani girl that came as an intern in the organization got the opportunity to be a part of the management of the organization. And I have to mention that that year it was both me and my colleague Vivian Brashoy. We were together promoted to legal managers. And just a year or two after that, we also got promoted to legal directors. And currently, we are both based on managing the legal work of ERRC, with one small difference that we have a specific portfolio that we are leading. I am in charge of international litigation, so the international cases that we represent, and my colleague Vivian Brashoy is in charge of domestic litigation. However, these two functions, these two portfolios intersect constantly, constantly work together. So that's shortly about me and my journey at the ERRC. For those of us that don't know, that never heard about strategic litigation, a very short definition is that that's a court case that it's aimed to bring some structural change, basically change in the regulation, change in the policy, change in the practice that is structural, that doesn't affect just one individual, but the entire society. And when it comes to the effects, for example, if we compare the traditional litigation and the strategic litigation, just to make it more illustrative for people, in traditional litigation, we usually, as I said, we have one individual, and we want to achieve effects for the benefit of that one individual. In strategic litigation, we have communities usually, or group of people who are facing same challenges. And then strategic litigation, it's basically that type of court case that would address this structural issue. And then also there is a difference in the outcomes because in traditional litigation, we have judicial decision as a final outcome. And in strategic litigation cases, we have as an outcome some change in behavior. It's not only the judgment. So we don't stop with a concrete judgment, but we stop when we succeed to say that we have changed the behavior of the defendant, meaning of the state or of the state agents. So if you talk about police brutality, for example, of the police to stop using police abuse against the Roma community in particular. So that would be an illustrative way of explaining it to you. In the European Roma Rights Centre, strategic litigation means supporting legal cases that are designed to expose and challenge the discriminatory structures that exist in the countries where Roma live, and basically prevent Roma from experiencing, again, discrimination, and making sure they enjoy full equality with the rest of the people in the countries where they live. So this would be more specific to what is strategic litigation at the ERRC. We work in several areas. We litigate in several areas. For example, some access to housing. And when we talk about housing, it's not just the right to enjoy your own home, to have your own home, and the right to private and family life, but also the access to utilities such as access to water, sanitation, proper waste removal. So all of the elements of adequate housing, including the security of tenure, which is very important for. Then we also cover the area of education, for instance, access to education of Romani children. The most famous large-scale case is school segregation of Romani children. Then we also have an area that deals with sexual and reproductive rights of women. And here we have cases, for example, that deal with compensation for sterilization of Roma women. Then we have all kinds of cases that relate to sexual reproductive rights. For instance, the problem with obstetric violence towards Roma women in the moment of delivery, cases of delivery in front of hospitals, and basically the discriminatory reactions of medical professionals or the discriminatory non-reaction of medical professionals. So all kinds of violations that relate to sexual and reproductive health. And also we have then the area of access to identity documents. As I mentioned, the issue of statelessness, that's also part of this area, but also certain parts of freedom of movement, for example, racial profiling of Roma at borders of different countries. But we also constantly we follow the different trends and issues that affect the global work and communities similar to the Roma, but also the Roma communities. And we try to involve this type of approach in our work and include new areas of work. The fact that we are not a homogeneous community, that members of our communities are facing double, triple forms of discrimination, and they all intersect. They are all important when we the case before different courts. So we have just ways of litigating cases of intersectional discrimination. But I think the one that I would like to discuss more is using the UN treaty bodies for this purpose, because the United Nations has its own treaty bodies that are expert in certain areas of discrimination. And when it comes to the women and their rights, we have there is an established committee, the UN CEDAW committee, that is in charge of supervising the implementation of the Convention for Elimination of All Forms of Discrimination Against Women. So we have litigated several cases before this committee that relate to intersectional discrimination of Romani women. And when I speak about intersectional discrimination, we rarely have only two grounds, such as gender and ethnicity. There is always a third or fourth ground as well that is included in the discrimination that women are experiencing. Those grounds might be, for example, the fact that we're talking about pregnant women, about mothers, and the challenges that they additionally face as Romani women being pregnant. Coming from from low socioeconomic background, also facing the challenges of living in shelters or in shacks or informal settlements, so being unregistered. So, for instance, a couple of years ago, we had a case where pregnant Romani women from North Macedonia, from the country of my origin, were evicted in the summer in very hot weather, and they didn't have any access to reproductive health, to water, to sanitation, to nothing. So we submitted this case before the UN CEDAW committee, and in less than 7 days, 7 work days, we received an interim measure from the committee obliging the government to provide as soon as possible, basically urgently, an access to reproductive care for all the women. We had 6 women applicants in this case, and also accommodate them, offer them alternative accommodation because they were evicted, and all other rights basically that are connected to their situation, to their condition. Also, last year we had a very prominent case that was present all over the social media and relates to obstetric violence of a Romani woman in Serbia. That's also a complex case of intersectional discrimination. So we are supporting the concrete litigant on domestic level in her case that it's against the concrete doctor, and the doctor is still under detention. for a couple of months already now, more than 6 months.
Just was coming to my mind when you were talking about intersectionality. I guess that it will be difficult for the judges, even in the domestic or international setting, to accept the intersection of different identities or circumstances for, in this case, Roma women, as intersectionality is not fully recognized in the legal procedures. What are the challenges that you are facing in this type of cases?
Exactly what we have courts that are very progressive, but also courts that, because the decision depends from the education and awareness of the individual judges who are part of these courts and who have to bring decisions. We have judges who read a lot, who want to develop further, and after their education, they also follow the newest case law of the European Court of Human Rights or of the UN CEDAW committee, and they try to involve this in their decisions. However, unfortunately, these are minority of judges. Majority of judges, and in general lawyers, we think that we know everything and we don't need to actually read and hear what's new, in the practice. So they are just focusing on their own context, usually their concrete country, and even if you bring examples of other countries, they would not be interested to hear about that. We have some countries already that have adopted definitions of anti-gypsyism in their national legislations. Some even criminalized the anti-gypsyism, and they included provisions in their penal codes. However, in practice, also in none of these countries that have laws, for example, in Romania and recently Czech Republic adopted just a definition of anti-gypsyism. In none of the countries we have cases that have been brought under these laws. So meaning these laws are not really utilized; they just exist on paper. And we have to see, is this that the public, that the people report cases under the anti-gypsyism laws, but the public prosecutors and the judges do not invoke properly those articles, or is it that it's just that these laws are so abstractly written that there is no use of them, and then it's better to use the general provisions of the penal code rather than have special laws. So that's a debate that for us at the ERRC, our key idea is to make anti-gypsyism a usable concept before national courts, but also before the European Court of Human Rights. We want to have a judgment where the European Court of Human Rights will recognize that the discrimination that Romani communities experience in Europe is result of anti-gypsyism. And so far, we managed to a certain extent to come to this point, where the court in several judgments have mentioned that Roma are especially disadvantaged and vulnerable community because of our history of persecution. So
you did perfectly. Just coming back a little bit about the role of the community in such a cases, because as you said, strategic litigation is not used to benefit one individual rather than to make structural changes to benefit the whole community. How the Roma community can be involved in cases of strategic litigation?
Strategic litigation as such, especially the Actio Popularis version or this public interest litigation, created, designed in order to protect minorities to not be victimized. Basically, to have at the forefront an NGO that will litigate on behalf of communities. On the other side, we want to make sure that the communities are visible, that they are present there. So we really need to make sure that we balance this thing, that we don't leave behind the communities, that we still all the time communicate to them what happens with the concrete case. We involve them as much as possible in the case, but trying to protect them, their well-being, their identity, and making sure still that the organization is adequately doing its job, basically that it's representing the case in the best way possible. So that's why I think it's very important to have this close communication with the communities. They don't need to be visible in the complaint in a way that we name all of the individuals that are taking the case forward. I want to protect their own privacy, their rights, and their identity because of the fear for facing repercussions by the state institutions. But we need to involve them from the beginning in the litigation. So in the past, what ERRC is doing, we had proactive and reactive litigation. And in many cases, lawyers were sitting at the ERRC and deciding what is the most strategic case. So this is what has changed throughout the years. So We are doing less and less that, designing cases for the Romani communities. What we do most is we follow what are the issues in the concrete country. We read the reports of the ombudsmans. We have meetings with the Romani community. We receive direct reports from people on our email addresses. And then we try to explore to see, is this a structural issue that it's affecting a bigger group of Roma people, or this is an individual problem affecting one Romani person. Sometimes an issue that at the beginning initially appears like an individual problem, at the end it might appear that it's a strategic issue. So we have a special project that we implement for 3 years now. It's called Mass Complaints Project, that actually has this key idea that the main focus are the communities. We have local monitors and partner NGOs that work on the ground, and basically all types of issues that Roma communities are facing are being reported to our monitors and local partners. And then what we do is we help the community to put together a complaint. So we are writing the complaint on basis of the information that they give us, and we submit it usually before equality bodies, because equality bodies are free of charge and they are more accessible than courts for the Romani community. And these complaints are really on all kinds of issues. And for example, there are communities that for them, the biggest priority in that moment, it's not, let's say, access to water, but for them is the roads to be paved so that they are able to go and come back from work and to provide for their children. So it really comes from the community, the decision, what they would like to be litigated. And sometimes if we see several issues in one community, we try to strategize with which issue we can go before which body. So that's the part of our work, basically to help the community to identify the best possible way for their issue to be solved. But it's not us who is deciding on what is the priority in that particular community as an issue to be represented before the bodies. So we also try to follow up with them anytime that there is a development in their case. If there is a court hearing, for example, we can propose some of the individuals who are the brave ones who would like to appear before the court and to talk about their experiences. We prepare them for these court hearings. We talk to them in order to make sure that they are confident in what they will present before the court, that they don't fear about speaking openly about their issue. And we also consult with them when it comes to a decision. So once we have a decision, we talk to them, do we need to follow up further with this decision, or they're happy with it, what it needs to be done, basically in order to make sure that we have change in behavior at the end of the day, that we don't have just a judgment and that's it, we close the case. And this is the most challenging part actually of our work, making sure that Romani communities are happy with the outcome of the litigation, and making sure that the governments are implementing these decisions and judgments that are being brought by their courts or by the equality body.
Thank you so much, Senada, for sharing all this important information that a lot of people from Roma community and also different minorities, they don't know that this is this legal tool that can make structural changes. And also I would say that many times Roma, they do not complain or report to the police the different discriminatory experience that they have, because they feel themselves alone and they don't really pursue their rights. So I see the role of ERRC and your role specifically as a legal director and representing, like a women role here, essential and at the same time very critical. So to close the interview, I will ask, what advice will you give to a young Roma women or girls that are aspiring to enter in the legal field or engage in human rights advocacy? What's your more essential advice that you will give to them?
For me, the most important thing in my work is that I'm still passionate. Even after 10 years of working for the ERRC, when I talk about Roma rights, I'm so emotional and involved in the topic. And I think that's what kept me basically in the organization. And I think they should be passionate about what they want to do. If that's the legal field, then continue with it. Go, girl, you can do it, but grab as much as they can. talk, be loud, don't be silent.
Mhm.
I
Thank you so much, Senada. It was really a pleasure to listen and to learn from you.
thank you.